My concern is that the majority's opinion in Trump v. the United States capaciously defines core constitutional powers to extend far beyond these well-recognized powers. Concluding that the investigation and prosecution of crimes is a quintessentially executive function, the majority holds that the former president is absolutely immune for alleged conduct involving his discussions with Justice Department officials. That conduct includes the indictment's allegations about efforts to leverage the Justice Department to convince certain states to replace their legitimate electors with fraudulent Trump slate of electors. The majority seems to source this in the Take Care Clause, but that clause says that the president shall take care that the laws be faithfully executed, explicitly recognizing Congress's role. Justice Amy Coney Barrett recognized this, writing separately that Congress has concurrent authority over many government functions, and it may sometimes use that authority to regulate the president's official conduct, including through criminal statutes. She would not read the Take Care Clause so expansively. Unfortunately, Justice Barrett's well-reasoned concurring opinion did not command the majority. The potential abuses of official power that are made possible by the court's ruling and the neutering of Congress's ability to act are alarming. Consider first the Department of Justice. Is Congress now disabled from tying the appropriation of funds to certain areas of law enforcement, or from enacting legislation that governs department organization and functions, or from oversight requesting records and testimony from department and FBI leadership? What would stop a president from directing the investigation of his political enemies, journalists, or activists, even where there is no basis for doing so? The majority said, after all, and I quote, "The indictment's allegations that the requested investigations were shams or proposed for an improper purpose do not divest the president of exclusive authority over the investigative and prosecutorial functions of the Justice Department and its officials." Could that sham investigation include directing the FBI to engage in unlawful surveillance, or bypass seeking a warrant to search a home or workplace, or to target individuals or groups based on race or religion? If the president were to bring a civil suit against the Department of Justice, as the former president has provided notice that he intends to do, could he order the department to settle the case for millions of dollars, even if the suit itself were baseless? Moreover, the rationale of the majority's decision would appear to apply to all departments and agencies. No potential criminal prosecution would prevent the president from directing the IRS to launch baseless criminal investigations. Likewise, no potential criminal prosecution would prevent the president from using the CIA for domestic operations. The reforms enacted by Congress in the wake of past abuses would be impotent in the face of a president unconcerned about adhering to the rule of law.